Hello to all my dear CA Foundation students. So today I am going to discuss the mock test paper that was conducted by the ICI, the mock test one. So let's just have a look into the question paper. Let's just see the question. Let's just discuss the answers to the same. So starting with the question, the first question. Ram owns an electronics store. Pankaj visited the store to buy a water purifier priced at 54,000. He specifically requested he specifically requested Rahul for a purifier with a copper filter. As Pankaj wanted to buy the purifier on credit with the intention of paying in 9 equal monthly installments, Rahul demands a guarantor for the transaction. So we are talking about a guarantee here. Suraj came forward and gave guarantee for the payment of water purifier. Rahul sold Pankaj a water purifier of a specific brand. Pankaj made payment for 4 monthly installments and after that became insolvent. Explain with reference to Indian Contract Act liability of Suraj as a guarantor pay the balance water. So basically, when a person gives any guarantee on behalf of another, the liability of the surety is coextensive to the liability of the principal debtor. And when the principal debtor makes a default, can we say Suraj is liable to pay? Yes. One more thing, please be careful. Let's say in the question, they don't tell you how much he will pay. Then you will say insolvency, so he doesn't pay the whole debt. If they don't say anything, you will just say the surety is liable. However, if they mention that now he's only going to pay, let's say 40% of his debts, then even the surety is only liable to pay 40% of the debts. What will be your answer if Rahul sold the water purifier misrepresenting it as having a copper filter while it actually has a normal filter? Neither Pankaj nor Suraj was aware of the fact upon discovering the truth. So, when a guarantee is obtained by misrepresenting the facts, the surety has no liability. Here, because it was misrepresentation, can I say Pankaj has a right to avoid the contract? Yes. Pankaj avoids the contract, Pankaj has no liability. And very obviously, if Pankaj has no liability, obviously Suraj also will have no liability. So is Suraj liable to pay? No. Next question. Moving on to the next question. A company, DEF Limited, as on 31/3, has a paid up share capital of 1 lakh divided into 10,000 equity shares. In June, DEF Limited issued additional equity shares. So total shares is how much? 20,000, of which MNO has taken 5,000. So basically, how much? 25%, which was fully subscribed. Out of 10,000, 5,000 MNO. MNO is a holding of JKL, right? So it is a holding of JKL. Now, JKL Private Limited claims the status of being a subsidiary of DEF as being a subsidiary of its subsidiary MNO Private Limited. So that is what they are trying to say is that JKL is saying that I am a subsidiary of MNO and MNO is a subsidiary of DEF. So I am also a subsidiary of DEF. Not possible. First, MNO is holding in DEF. DEF is not holding in MNO. So DEF will in no situation or no condition be the holding of MNO. Now here, MNO is holding only 5,000. So there is no holding subsidiary relation. So is it correct? This is not correct. So the claim validity is not correct. So basically here, I have to write provisions about what? Holding and subsidiary, correct? State the relation, if any, between DEF and MNO. So is there any relationship between DEF and MNO? DEF का shares, MNO is holding 25% of the shares of DEF. So on this, we can say they have a relation 25%, which is significant influence, which is associate company. So can I say that DEF is an associate of MNO, right? So the second provision that we have to write here is about associate company. Moving forward, referring to the provisions, answer if partner is otherwise expelled, the expulsion is null and void. So basically, you have to write 3 conditions. It should be with the consent of majority, it should be in good faith, and it should be there should be an agreement which gives the right to expel. Good faith is all the 3 conditions: interest of partnership, and partner to be expelled is served with a notice, and he's given an opportunity of being heard. The expulsion is not in good faith; it is null and void. So yes, this statement is true. The partner who is expelled will cease to be liable to the third party for the act of the firm done after the expulsion. Well, true. If a partner has been expelled from the firm then he and his existing partners will continue to be liable for any act done before his expulsion, not after his expulsion. So, yes, in this case, they will not be liable. They are only liable for the acts done before his expulsion. However, if after expulsion any third party deals with the firm not knowing that this partner has been expelled, his liability is over. I am expelled, my liability is over. So yes, he is liable only up to the date of his expulsion, not afterwards. Ashish, a trader, delivered a camera to Mohan on sale or return. So Ashish gave his camera to Mohan on sale on approval. Mohan delivers the camera to Raj on terms of sale on approval on cash basis. The moment Mohan gave it to Raj, as between Akash and Mohan, Ashish and Mohan, it is a sale, correct? Now, N gave it to R on sale on approval on cash basis. When it is sale on approval, ownership is transferred when the buyer gives his consent or retains the goods or does any act which is consistent with ownership. Here, when he gives it to R, he has done an act which is consistent with ownership. So it is as between Ashish and Mohan, it's a sale. Mohan gave it to R on sale on approval on cash basis. Here, ownership will transfer only when the cash is paid. Afterwards, Raj delivered it to Vikas. Afterwards, Raj delivered it to Vikas on sale on approval. Vikas had taken the camera which was in the possession of Vikas was lost by theft, though he exercised due care. Referring who is liable to pay the price of the camera to Ashish. Let's start with Vikas. Is Vikas the owner? No. Was it his fault? No, because he exercised due care. So definitely Vikas is not liable. R, that is Raj, had given his goods to Vikas on sale on approval. But between Mohan and Raj, it was very clear it is on cash basis. So Raj would have become the owner of the goods only when he had paid the cash. He has not paid the cash, so he's not the owner, so he's not liable. Who is liable? Mohan. Why? Because as between Ashish and Mohan, it's a sale. Akash of Jaipur sold 100 smart TV sets at 50,000 per set to Barun of Delhi. He delivered the TV sets to Chirag, a transport carrier, for transmission to Barun. Barun further sold those 100 TV sets to Sarthak at 600 per set. 60,000, I'm so sorry, 60,000 per set. On reaching the goods at the destination, Barun demanded the delivery, but Chirag wrongfully refused to deliver the goods to Barun. So the goods acknowledgement has been done. The buyer is ready to take the delivery. That is why he failed to deliver the sets to Sarthak and suffered a huge loss on account of non-delivery. So here, on reaching the goods, but Chirag wrongfully refused to deliver, can the buyer claim damages for non-delivery of goods? Yes. Akash comes to know about this. He directed Chirag to stop the delivery to Barun and re-deliver the goods to him at Jaipur. Whether Akash has a right to stop the goods? No. Why he has no right to stop the goods? The moment Barun acknowledges the goods with Chirag and Chirag wrongfully refuses, the transit has already come to an end. The transit has already come to an end. And when transit comes to an end, you don't have any rights of stoppage in transit. Also, stoppage in transit can be exercised only in the case of insolvency. Whether Barun can claim damages due to loss suffered. Yes, because he was refused to deliver the goods. He has a right to claim for non-delivery of goods. So yes, he can claim damages for non-delivery. Ram wants to incorporate a company in which he will be the only member, OPC. According to the provisions, what type of company can be incorporated? What are salient features of this type of company? So only a natural person who is an Indian citizen, whether resident in India or otherwise, and has stayed in India for 120 days in the immediately preceding financial year can become a, what do you say, a nominee or a member of an OPC. In case of an OPC, the nominee's consent will be taken, written consent, which will be filed with the ROC. His name will be there in the memorandum. The member can withdraw his nomination, and the nominee can member can change his nomination, and nominee can withdraw the nomination. In both the cases, a new nominee has to be what do you say, appointed. Then, how many companies can I be a member or nominee? I can only be a member of one, and at the same time a nominee of one other OPC, but not more than one. If a person becomes a nominee of, or if a person becomes a member of more than one OPC, why would he become a member of the second OPC? Because of nomination. Within 180 days, he must fulfill the requirements of the Act. There are certain restrictions. Minor cannot become a member or a nominee of an OPC. It cannot operate as a Section 8. That is, it cannot incorporate or convert into a Section 8 company, but it can convert into a private or a public company. And it cannot carry the business of NBFC, including investment in securities of any body corporate. Referring to the provisions of LLP, under what circumstances an LLP is compulsorily required to change its name? So when an LLP has been incorporated with a name by inadvertence or by any reason whatsoever, has been incorporated by a name which is identical to the name of any other LLP or company or registered trademark, then an application can be made by the LLP or the company or the proprietor of the registered trademark to the central government asking the new LLP to change the name. Proprietor can only make the application within 3 years of incorporation of the LLP or change of name of the LLP. Once this application is made, central government will order the LLP to change the name. Within 3 months, LLP must change its name. Within 15 days of change, send a notice of the change to the registrar along with the order of central government. Registrar will make a change in the certificate of incorporation, and this certificate of incorporation, the LLP, the day it gets, within 30 days, it should make a change to the LLP agreement. If LLP fails to change the name, then in that case, the central government will allot a new name and the LLP will be using that name. Registrar will record that name. What do you mean by small LLP? Where the contribution of the partners does not exceed 25 lakh and the turnover as per statement of accounts and solvency in the immediately preceding financial year does not exceed 40 lakh, then you are a small company. Both conditions fulfilled. Ram and Shyam are partners in a partnership firm named as RS and Company. Gaurav, a renowned businessman, is their common friend. Ram introduced Gaurav to Sahil, a supplier, as his newly joined partner. Gaurav, knowing that he is not a partner, preferred to keep quiet. This is what? Partnership by estoppel. On such an introduction, this information about Gaurav being a partner of the firm was shared by Sahil with another businessman. So he was introduced to Sahil. So that means, is he liable to Sahil? Yes, he is liable to Sahil. This information was shared with another businessman, Madhav. The question is, if I share this information with Madhav, is the partner also liable to Madhav? That is, partner by estoppel also liable to Madhav? No. The liability is only to the person to whom the representation is made and not to any other person. So towards Madhav, he will not be liable. Next day, Sahil supplied the raw material on credit and Madhav lent 5 lakh to the firm for a short period on the understanding that Gaurav is a partner of the firm. On due dates, the firm failed to discharge its liability towards both. Advise Gaurav whether he is liable to Sahil? Yes. Madhav? No. I hope clear. On admission as a new partner, Ashwin agreed to be liable for the existing debts of the firm by an agreement signed by all the partners, including Ashwin. Can a new partner who has joined the firm agree to be liable from a prior date? Yes. Generally, the liability of a new partner is from the day he joins the firm. However, with his other partners, he can agree to be liable from a prior date. Examine whether Ashwin will be liable in a suit filed by the creditor against the firm and all existing partners. They are not asking his liability to the creditor and existing partner. They are saying if the creditor files a case against the firm and the existing partner, is Ashwin also liable? When a partner agrees to be liable from a prior date, this agreement is between Ashwin and his other partners, right? The creditor is just an outsider to their contract, privity of contract. Can the creditor sue this contract? No. The creditor can only recover the money from the old partners. The existing partners may recover it from Ashwin, but the creditor has no right to sue Ashwin. Why? Because this I am liable from a prior date is between my partners, not with the creditor. So is Ashwin liable to the creditors? No. MN Limited borrowed a secured loan of 5 crore from Star Bank to meet its working capital requirement. However, the borrowing powers were restricted to 1 crores. The bank released the loan. They have taken a loan of 5 crores. Only 1 crore was allowed. So 1 crore they are liable to pay. 4 crore they are not liable to pay. Correct or not? The bank released the loan amount in 2 installments of 1 crore and 4 crore. On the due date, the repayment of the loan, the company refused to accept the liability of 5 crore. वैसे भी company is liable for 1 crore, not for the 4 crore. On the grounds that the borrowing was ultra vires the company. The company's books of accounts show that the company has utilized the loan amount of 3 crores for the repayment of lawful debts. Now, when the company has taken an ultra vires loan, but the loan can be assigned to any lawful debts, then the lender steps into the shoes of the creditor and the company is liable to pay that money to the lender. The utilization of remaining 2 crores cannot be traced. So, this 1 crore they are liable. Out of the 4 crores, 3 crores is traceable. So they are liable for this. So they are liable for the 1 crore plus the 3 crores. But the amount which cannot be traced, they are not liable. After incorporation, on 15th May, the share certificate were issued to Arnav, Sohail and Suman being subscribers to the MOA without affixing the common seal. So there is this one provision that if you have a common seal, the document must have a common seal, your company's common seal. However, we know common seal is not mandatory. So if a company does not have a common seal, then the document shall be signed by 2 directors or 1 director and 1 company secretary if the company has appointed. Ma'am, if I have appointed company secretary, can I not have his signature and just 2 directors sign it? If I have appointed a company secretary, it is mandatory company secretary must sign it. So, thereon and under the signature of Arnav and Sohail, the directors of the company. The company has not yet appointed a company secretary. Then who will sign it? Common seal or 2 directors. They are saying, okay, common seal they did not put. On objection raised by Suman, a director, about the validity of the share certificate signed by other 2 directors, Arnav and Sohail clarified that company has opted not to have the common seal. So if I don't have the common seal, who will sign it? 2 directors. So is it valid? Yes. Referring to the provision, examine the correctness of the objection raised by one of the directors and in response the clarification. So this objection raised by one of the directors is not valid and the clarification given by the other directors is absolutely valid. What would be your answer? Would your answer be different if the company had appointed? Yes. Yes, answer would be different. Then the objection would be valid. Why? Because if the company has a company secretary, the company secretary must sign the document. Explain the term wagering agreement. An agreement to give money or money's worth, happening or non-happening of a future uncertain event. The event is the sole determining factor of a wager. In India, wagers are void, but in Gujarat and Maharashtra, they are also illegal. In case of wagers, both the parties are said to win and lose. What are some transactions? Some transactions resembling wager, insurance contracts, chit fund companies. Then you have this athlete competitions, crossword puzzles. These are, even though they look like wager, but they are not wagers. R executed a loan with D with X, Y, and Z as sureties. Each surety executed a bond with varying penalty amounts. X with a penalty of 10,000, Y 20, and Z 40. Please remember, this is not our ratio. This is the maximum amount that I am liable to pay in the event of D's failure to repay the borrowed money. Examine the liability of the sureties in accordance with the Indian Contract Act when D defaults to the tune of 42,000. So if D defaults to the tune of 42,000, then in that case, how much would each of them be liable to pay? Now, 42,000 X is anyway saying I'm liable for only how much? 10,000. If I divide 42,000 into 3 equal ratio, it comes to more than 10,000. X is only liable for 10,000. So what is X liability here? 10. After X ka 10,000, how much is left? 32,000 is left, which will be shared by the others in their in equal ratio because everything is equal. But because X said I'm only liable till 10,000, he will pay 10,000. How much is left? 32. 32 means what? Each of them is liable to pay 16,000. Since Y says 20,000, it is within 20,000, he is liable. Z ka 40, it's within 40,000, right? What would be your answer if there was no agreement amongst the sureties? Okay. If there was no agreement between the sureties, then in that case, they would be liable to share it what? Correct or not? That means each of them is liable to pay 14,000, right? So in the first case, no, when they agreed 10, 20, 40, each of them is liable for how much? 14. But X says I'm liable only for 10. So that is why he is liable for 10 and uska 4,000 will be shared between. X agrees to pay Y 1 lakh if Y kills Z. X says to Y, I will give you 1 lakh if you kill Z. And to pay this money, X borrows the money from W and W is also aware of the purpose of the loan. Y kills Z, but Y kills Z, but X refuses to pay. X also refuses to repay the loan to W. Explain the validity of the contract between X and Y. Can I say the contract of X and Y is illegal? Yes. And the validity of X and W. Any contract which is collateral to the main contract which is illegal is also void. It's colored with illegality and hence void. A promissory note payable at a certain period after sight must be presented to the maker. Under what circumstances presentment for payment is not necessary? When I'm supposed to present it during the business hours, I come to your office at the business place and it is locked during the business hours. We have decided on a specified place and you are not present at that specified place. Or when there is no specified place and I cannot find the person, reasonable search. When I have made a part payment or where I have where it's very specifically given that presentment will not be done or where the maker uh, waives off his right of presentment or the party will not be suffering any loss if no presentment is done. In all of these cases, no presentment is necessary. What do you understand by law? Elaborate the procedure for making law. Law are set of rules and obligations which the society has to follow. Procedure of making law: a bill is made which is laid down in first the Lok Sabha and then the Rajya Sabha. First pass that Lok Sabha, then pass that Rajya Sabha, then the president signs it, then it is notified in the official gazette. Excuse me. Only after it is notified in the official gazette, it becomes an act. Karan agreed to sell his laptop to Vishal for a price to be fixed by Kiran, a hardware engineer. So basically, third party is fixing the price. However, before the delivery of the laptop, Karan changed his mind and did not share any particulars and configuration of the laptop with Kiran, which made her unable to do the valuation. Kiran refused to do the valuation. If the third party refuses to do the valuation, contract is void. However, if the third party is not able to do the valuation due to the fault of any of the parties, then the aggrieved party can claim damages from the other party. Here, it is very clearly given Karan changed the mind and did not share the configuration with Kiran. So, whose fault is it? Karan's fault. So, is he liable to give damages to Vishal? Yes. Vishal needed laptop for his project, so he promised Karan that if the laptop is delivered to him, he would pay a reasonable price for it. However, Karan decided not to sell his laptop to Vishal. Now, Vishal wants to know from you, being a legal expert, whether Karan is bound by the promise. No. And the third party refuses to fix the contract is void. If does not agree to deliver, what is the other remedy available to Vishal? Vishal can actually claim damage, right? Mrs. Meenu went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price of the same as 125 per kg, to which she agreed. Mrs. Meenu insisted that she would like to see the sample. That means this is what? Sale by sample of that which would be provided to her by the shopkeeper before she agreed upon such a purchase. The shopkeeper showed her a bowl of rice as a sample. The sample exactly corresponded to the entire lot. So what she got, the goods she got, was same as the sample. Mrs. Meenu examined the sample casually without noticing the fact that even though the sample was of basmati rice, it contained a mix. Whose fault is it? Mrs. Meenu's fault. The cook, on opening the bags, complained that the dish, if prepared was with the rice, would not taste the same, as the quality of rice was not as per the requirement of the dish. Now, Mrs. Meenu wants to file a suit for fraud against the seller. Can she file? No, there is no fraud. Alleging him of selling a mix of good and cheap quality. That was what she saw. The sample was there. Will she be successful? No. No, because the bulk correspond to the sample and she had examined the sample. What would be your answer in case she specified her exact requirement as to the length of the rice? If she specified her exact requirement as to the length of the rice, it would be conditioned as to quality and fitness for the specific purpose of buyer. And in that case, can she return the goods back? Yes, she can return the goods back. Indian Partnership Act does not make registration of firms compulsory, does it impose any penalty for non-registration. Partnership registration of partnership firm is optional but desirable. And as such, English Partnership Act lays down a penalty, but under Indian Partnership Act, we don't have any penalty for non-registration. In light of the given statement, discuss the consequences of non-registration. If a partnership firm is not registered, third party third party can sue the firm, though the partnership firm cannot sue a third party. It can claim a set off of not more than rupees 100. So it cannot claim a set off of more than rupees 100. And third, partners cannot sue each other except for the dissolution of the firm. In case of breach, the court may award compensation or damages. Explain the circumstances when court may award ordinary. Ordinary damages are those which arose naturally in the contract and can be claimed as a right. It is basically a difference between market price and contract price and can be claimed as a right. Special damages cannot be claimed as a right. You can only claim it when you have mentioned it in the contract. That is, a notice of the same is given. Liquidated damage is a pre-estimation of the actual damage the parties try to figure out so that in case of any breach, the aggrieved party at least has a remedy to claim the damages. He will only get the amount mentioned or suffered, whichever is less. What are the conditions that need to be fulfilled to make the following agreements valid without consideration as per the provisions of the Indian Contract Act? The general rule is a contract without consideration is void. However, there are certain exceptions. In case of agreement made based on natural love and affection, if the contract is made between parties who stand in a relation, they make a contract out of love and affection and they get it written and registered. It's a valid contract. A promise to pay a time barred debt, a written promise to pay a time barred debt is valid. So if the debtor or his agent authorized by him give a written promise to pay a time barred debt, the contract is valid. Mr. M issued a check for 10,000 to Z, which was dishonored by the bank because Y did not have enough funds in his account. Dishonor of check due to insufficiency of funds and had no authority to overdraw. Overdraw means basically, sometimes it happens that you don't have balance in your account, but the bank lets you overdraw and you will pay the bank later. Examined as per the provisions of Negotiable Instruments Act, Mr. Y is liable for dishonor of check. Yes, he is liable. If yes, what are the consequences? Twice the amount of the check or up to 2 years or both? What would be your answer if he had issued the check as a donation? Now, the liability under this section arises when it is for a legally enforceable debt. The check is presented within the time. Once the banker gives a notice to the holder that your check has been dishonored, he should within 30 days give a notice to the drawer that your check has been dishonored. Within 15 days, if the drawer pays, fine. If the drawer does not pay, then he'll file a case. If the check was given as a donation, it was not for a lawful debt, then in that case, he will have no rights, or rather, I should say, the drawer shall not be punishable under Section 138. What is quasi contract? The characteristics. A quasi contract is a contract which is not created by a contract or an obligation not created by a contract, but it is imposed by law to prevent the unjust enrichment of one at the expense of other. The characteristics are it is an obligation which is created without any contract. The obligation is against a person, a specific person, and not against the world at large. And this right is only for a sum of money, generally a sum of money, or in some cases a liquidated sum of money. What is the difference between sale and hire purchase? In sale, ownership is transferred immediately. In hire purchase, the ownership is transferred on the last installment. In sale, you don't have an option to return the goods. In hire purchase, you have an option to return the goods. In sale, the person who purchases the goods is the owner of the goods. In hire purchase, he's just the value of the goods. In sale, if the buyer resells the goods, the new buyer gets a good title. In hire purchase, if the hirer resells the goods, the buyer will not get a good title even if he's a bona fide purchaser. And in hire purchase, if there is any loss due to insolvency of the buyer, the loss is not borne by the seller. But in case of sale, if there is any loss due to insolvency of the buyer, that loss is borne by the seller. So I hope you were able to solve the question. Do try writing answers. I hope your studies are going well, learning and stay motivated.